Hello, and welcome to our webinar. I want to thank you so much for joining us today to establish whether or not you need a trust. And if you don't need a trust, you certainly need an estate plan, and a will plan may be just enough for you. So I want you to follow along, perhaps take some notes. Please stay until the end, because at the end, we actually have a rather nice surprise for you. And if you do book a 15-minute call with us, you will have the ability to receive a discount as a result of sticking until the very end. So here we go. Do you need a trust? So this webinar is entitled, Do You Need a Trust? Because it is the most common question that I receive when people reach out to me. So first I'm going to share with you who I am. My name is Denise Littell. I graduated from Seattle University School of Law a very long time ago. I am licensed to practice in Florida and DC, and I worked for 15 years in the trust industry. Essentially, I worked as a trust advisor in banks, in their trust departments, advising clients as to their trust. How exactly did I get here? Well, you'll see my father, who is on my left, so you're right. He was in the military. He fought both in Korea and Vietnam. And when you are deployed out to war, you are provided with a will, as well as some death benefit documents for your family. So part of the reason that I am somewhat comfortable with discussing these topics has to do with the fact that it was part of my growing up. My mother was orphaned by the age of 3, losing her mother at 2 and her father at 3. And her greatest wish, which she conveyed to us quite often, was to see us into adulthood. She was somewhat terrified that she would not live long enough to see, especially my younger sister, reach the age of 18. Fortunately, she exceeded that by quite a bit, but still passed a bit too young, in my opinion, 74. But she did live long enough to see her children as grown-ups as well as her grandchildren. So my goal today is really to take the mystery out of trust and help you decide if one is right for you. I'm going to first just take a step back and talk about estate planning, or the estate plan in general. These are really just legal tools that allow you to manage your assets, your belongings, during your life and after death. This typically includes a will, maybe a trust, power of attorney, and healthcare directives. This, by the way, is not just for the wealthy. Every adult should have these documents in place. So what makes the trust so unique, and what makes me a huge fan of the trust, is that it is a container. Think of it as this huge container in which you place all of your valued possessions within. So likely your home, your investments, savings account, perhaps CDs, some of these other things that you may want to have within this container. So it's a legal entity. The trusts that I'm discussing today are those in which you would create. You would also be the trustee, basically managing the trust, as well as the beneficiary benefiting from the trust. So I like to use the term trust maker. Quite often you will see the term grantor or trustor. Trust maker is much easier for people picking up the document to figure out which role that is. So that's my personal preference. Now, there are several types of trust, revocable and irrevocable. Today, we're talking about revocable trust. The basic difference is that an irrevocable trust really can't be changed without dramatic need and court action. Whereas the revocable trust, by the way, becomes irrevocable upon the passing of the trust maker. So that would be you, which is great because that means that after you have passed away, someone just can't willy-nilly change the terms of your trust. You've set forth what it is that you want, and that has to be adhered to and can no longer be changed once you have passed away. So what really is the difference? The key differences are that trusts avoid probate and ensure privacy. A will requires probate and is public. The trust, you can manage assets throughout your lifetime, and the assets can be managed or distributed upon your passing. The will is only serving the purpose of distributing your property, your belongings, after your death. So just to reiterate what the trust can do that the will can't, the trust can avoid probate. The trust can maintain privacy. The trust includes provisions for incapacity, so when you're no longer to make your own decisions. The trust controls the distribution, and the trust can protect assets. A will most certainly does not do that. The common reasons that you need a trust: you own property in more than one state, you own a business or rental property, you want to minimize estate taxes, you have a blended family. By the way, 40% of all families in the United States to date are blended families, and a lot of the conflict that I see is stemming from the lack of planning by parents of blended family scenarios. Just a thought. Now, also, if you have a special needs child, there's very special planning that you'll want to do for yourself, as well as adding for that child with a disability who may be or may be not already receiving public benefits. So I like to do this story because I just don't want people to think, come to me, I'm going to do your documents. Sometimes you've had documents done, and sometimes they're okay, but then sometimes they're out of date, and sometimes they're not okay. So in this instance, someone came to me. She had done her estate planning, and her sole focus and concern is her adult child who has disabilities. So he was born with a disability, and he is receiving public benefits. So she went to an attorney that did not have the specialization, and as it turns out, things were left to him outright. And of course, this was not good because, again, he is receiving public benefits, and this would most certainly interfere with his public benefits, potentially cut them off indefinitely. So what we did do is, first of all, fund her trust. So quite often people have trusts done. They don't transfer their assets into the trust. So what you have there is very expensive paper because it's useless unless the assets are actually placed into the trust. We set up an ABLE account for him, so Achieving a Better Life Experience is what it's called. These accounts are held throughout the country. The state of Florida has its own. What this does is allows individuals with disabilities to have savings. Currently, the individual must have been diagnosed with a disability prior to the age of 26. In 2026, that will increase to the age of 46, which is huge and which was lobbied on for many, many years. So now, as long as you've been diagnosed prior to the age of 46 with a disability, or I should say not now, but as of 2026, an ABLE account will be able to be used. No pun intended. We also set up a pooled special needs trust. He is an older gentleman, and again, the funds were not so substantial that he needed basically an individualized trust. The pool trust is perfect for him. And we also created a plan of care for assistance. He's in his 50s, his mother is quite a bit older, his siblings are in their 70s. So there has to be some thought process as to, in the event that something happens to the siblings, um, who then will continue the care, who will continue to look after him. And this is something, of course, that is unpleasant for people to think about, but you really have to for peace of mind. So I consider this to be one of the best examples of how comprehensive estate planning can ensure peace of mind across generations. Now, excuse me, when a trust may not be necessary, you really don't own much. You might be renting your home, for example, or you just don't really mind probate. You're comfortable with public proceedings and court supervision. That's really what probate is, by the way. It is court supervision of the distribution of assets when it comes to the oversight of a will and estate. And you have very, very simple wishes. So you don't need a trust in this instance, or you don't believe that you do, and that's okay. You will want to think about having a will, most certainly, as well as your healthcare directive documents to ensure that someone is able to make decisions for you in the event that you cannot. So I'm going to take a step back and look at the revocable living trust again. So this is created during your lifetime. It can be revoked, it can be changed. Typically, people are funding or transferring into their trust, their home, their savings, other investments. You will need a pour over will. What that does is it pours over or transfers into your trust those things, assets which were not in your trust at the time of death. What this does is it ensures that anything you forgot to place into the trust goes into the trust so as to avoid probate. So how the trust works, it's created by you. It's funded either by you or with the assistance of our office, for example. You will manage the trust as the trustee. You can, however, appoint someone to manage that if you prefer to do so. Your successor, the person who steps into your shoes upon your death, will distribute the assets or continue to administer the trust depending on what your wishes are or were. So let's talk about the cost of doing nothing. Very expensive. First of all, you have probate, that court supervision. The dockets are full. It takes forever. You're looking at generally 9 months to a year or longer, can be much longer if there's any type of family conflict. Speaking of family conflict, doing nothing usually creates that. There's a he said, she said, mom promised me this, no, she promised me whatever. This creates a dynamic that is not settled and could be settled simply by having written down what the wishes are. Loss of privacy, again, this is filed in court, it's public record, and you're going to pay, or your family really, much higher fees later. So what does a trust cost? In my office, a trust with the full service starts at $3,500 and can go up to $6,500. And when I say full service, this means you're being consulted through the entire process. You don't need a trust, or you don't think that you need a trust, then you will do the family will plan. That starts at $1,500 for a single person, $2,500 for a couple. The peace plan typically includes some sort of special needs planning or elder law planning, in which case that is at the $6,500 to the $10,000 range. So let's look at the cost of doing nothing. So I have a client, Sue. I usually ask people to take out their calculators at this point. Let's say that Sue had a home that she left for $350,000. She also had a life insurance policy for $100,000. Didn't name any beneficiary on the life insurance policy. That's also part of her probate. And a CD with also worth $25,000. also didn't leave beneficiaries named for any transfer upon death. So there you have it. All of her assets are going to probate: the home, the life insurance proceeds, as well as the CD. So we're at $475,000. I'm going to say 3% modestly it's going to cost with all the fees involved, but it may be up to 5%. So let's say modestly 3%. We're looking at the 350, the 100, and the 25. So you're coming at $475,000 total for her estate. The 3% value puts her at the cost at $17,250. The 5% value, which may be honestly the more likely of the two, is $23,750 that it will take out of her family's pocket, as opposed to her paying perhaps $3,500 for a trust or the $1,500 for a will planned with a ladybird deed. I'm not going to discuss that in detail here, but this is another option to keep a property, a home, out of probate. The typical retainer by most attorneys is between 10 and 12,000, and it is rising because the costs are rising. So how we can help, we do customized plans. We do flat fee hybrid pricing. We will review existing documents. If you hire us on, we'll review those for free. Sometimes people just want us to review them and let us know what's in them, in which case we will charge for that. We have a peace of mind plan for minors, essentially parents naming who they would want to look after their children when they are no longer around, as well as special needs planning. So what do we want to do next to unlock the discount and start organizing your affairs? Well, the first step is really to schedule a 15-minute consult, and you should do that after watching this video. Then, after the consult, you should schedule a life and legacy session with me. This is valued at $750. Finally, if you engage our services, you will receive a $250 discount. And if you mention your webinar attendance and the golden ticket, the full value will be $1,000. So there's the $750 consult that we will waive, as well as the $250 fee that we typically charge. So that is a $1,000 saving by watching this video until the end and booking that initial consultation, and then the life and legacy session, which is 90 minutes. And again, this has a value of $750, which we will waive. And then finally, we will give you a discount of $250 off of your plan, total value of $1,000. So frequently asked questions that I get are, do I lose control? Absolutely not. That's the beauty of being the creator of the trust maker, the trustee, and the beneficiary. What if I don't fund it? I hope that I made that clear, but if I did not, then you have bought some very expensive paper. Can you change it later? Absolutely. That's the beauty of the revocable trust. And do I need both a will and a trust? Well, if you have a trust, as I discussed, you'll definitely need the pour over will. You can have a will without a trust, but know that a trust, or that a will, very important, a will has to go through the probate process, the court supervision. So I want to thank everyone here for all of your time and your attention. I do have a QR code up, as well as my Calendly if you would like to book the 15-minute consultation. And from there, we will advise you as to how to book the life and legacy session with me, which is again 90 minutes and golden whether or not you actually engage our services. So I hope that this was helpful and that you know now whether or not you need a trust. Thank you.